The Cannabis Detector is brought to you commercial and advertisement-free through listener support. This enables us to avoid any real or perceived conflicts of interest and bring you unbiased insight into the California cannabis industry, free from any individual corporate or political influence. If you find this podcast informative, entertaining, or valuable in any way, please lend your financial support so we can continue this important work. Visit us on our Patreon page at patreon.com/cannabis to learn about your giving options. On behalf of all the staff here at Soil to the Oil Media, thank you for your support. For Soil to the Oil Media, this is the Cannabis Detector with your host and California cannabis industry expert, Kristen Yoder.
I would like to introduce my guest today, Ian Stewart with Wilson Elser Law Firm, to talk about the big wave of lawsuits, class action lawsuits that are about to be hitting California and are already starting. And I'm so glad you could join me. Thanks for coming on.
Thank you, Kristen. Great to be here.
Yeah, so wow, the brass knuckles class action lawsuit that is gonna cause ripples throughout the industry big time, especially since it's not just brass knuckles, but there's also C.L.A.Bs involved. Is C.L.A.Bs involved in this case?
Yes, C.L.A.B is one of the defendants in that lawsuit.
Okay, so can you first tell me what is a class action lawsuit? What is a class?
Sure. Well, a class action is a procedural vehicle meant to allow large groups, usually of consumers or customers, others as well, but frequently in California, we see these consumer class actions where large groups of consumers can be represented by one or a small number of representative class members. So essentially what this means is some customer who's gone into a store has suffered some loss or harm because of the product that he or she bought. And that person then brings the lawsuit on behalf of the entire class of people. And that could be anything from a few dozen people at the very bare minimum up to many, many thousands of people and potentially all customers who have bought that product, anywhere in the United States over a course of years. That would be the largest classes that have been seen.
Who pays for legal representation when it comes to a class action lawsuit?
Well, so most states and certainly the federal statute have laws that discuss how class actions are formed, and almost without variability, the attorneys that bring the suit, who are called the class attorneys, take their fees out of the recoverable amounts, either by settlement or judgment. So they typically take about a third of the class settlement.
So obviously, the lawyers are very very motivated to win because they're working for the win.
Yeah, if it's a class that has a lot of members and if each individual member stands to get something more than just a very nominal amount of money. So think of, for example, the Toyota litigation with the sudden braking, or some other cases that have involved larger amounts that each individual class member can obtain. So, for example, we've also seen solar panel class litigation in California, where each potential class member may get thousands of dollars in rebates or other value from the class settlement. Those attorneys stand to gain a very large win, and sometimes they can be really hard to settle because of the incentives that drive the attorneys.
That makes a lot of sense. I'm looking at this case, and having been in the industry for so long, I'm thinking, well, I know lots of companies that we could sue. Like, can I just go out there, buy a bunch of products, get them tested, and then sue everybody? Because I know tons of people that would join in on every class of each lawsuit.
Well, I guess the short answer is yes, potentially. I mean, we've been, meaning my team here at Wilson Elzer and the cannabis practice have been watching for this kind of scenario to start unfolding in California. And frankly, we were a little surprised that it took as long as it did to start seeing now these class actions being filed. And not only do we have the Brass Knuckles lawsuit in Los Angeles County, but also in early May, we saw the class action filed against Ease up in in the Northern District of California, in the federal court up in San Francisco, and there will be more. And basically, the way that these work, for the most part, is a customer goes in, identifies either along with the assistance of an attorney, identifies technical violations of the cannabis regulations that would potentially make that product somehow adulterated or misbranded, or there's false advertising, or there's some violation of the cannabis laws that make the product quote unquote illegal, or that the consumer has a cause of action. And then the California consumer protection statutes allow that consumer to use those statutes as a sword to bring these consumer class actions and seek all sorts of nasty remedies, including disgorgement of profits and compensatory damages, of course. But they can get attorney's fees frequently, not just fees at the end of the, meaning not just the attorneys in the class getting a part of the actual settlement or judgment, but the attorneys can actually keep track of their time and get their billable fees out of the settlement as well. So it drives the value up even further, and also punitive damages potentially.
I think that well, first, why wouldn't could a company lead a class action lawsuit against their competition by proving that, hey, you said you do this, we got it tested, that's not what it says, and we're going to sue you? Or can it only be consumers?
A company typically wouldn't be part of a class of individuals that are injured by some allegedly deceptive or wrongful business act. But what does happen frequently are competitor lawsuits, where one competitor sues another for the very same type of violations and under the same type of consumer protection statutes. However, those are one-on-one lawsuits typically. There's a federal statute, for example, called the Lanham Act. Lanham is how you spell it. But the Lanham Act is a very similar federal unfair competition statute that a lot of companies, so for example, the dietary supplement industry went through this some years ago, where companies sued each other under Lanham Act or other similar types of statutes, where they're saying that one company engaged in unfair business practices that allowed that company to unfairly compete in the marketplace to the detriment of the other company. We expect to see those as well, that type of lawsuit.
I would definitely think that that's going to happen when it comes to licensed companies versus unlicensed companies. But I guess that's a whole other battle there, because one is illegal, so they shouldn't be operating anyways. But as long as there's no enforcement, I already know there are a ton of really pissed off licensed operators that are like, why did I go through all of this if now my market has shrunk down to like 1/10 the size it was? If I would have just stayed unlicensed, I'd still be making a ton of money. I wonder if but that's not a competition thing either, is it? If you're licensed and you're suing against an unlicensed operation?
Look, I think that type of lawsuit actually could be relatively straightforward, meaning that if you're the licensed company and there's an unlicensed competitor that's across the street or within a geographic proximity or competing in exactly the same market, for example, that where you have the evidence to show that you've been harmed, you as the licensed entity have been harmed by sales being diverted away from you. This is what these lawsuits are designed for. So absolutely, those companies do have recourse in the courts through this type of civil tort. That's what it's designed for.
I've been in LA in the industry since 2005, and in 2007, the city created the interim control ordinance. And a lot of people in LA are like, oh, is that a pre-ICO dispensary or whatever? Meaning they were part of the 186 dispensaries that got in under that. And the city made them go through a lot of hoops to get that designation. And then the city did nothing to enforce, protecting the pre-ICO dispensaries. And I don't know who it was or who it was against, but I recall that there were a lot of lawsuits against the city and against each other for them still operating. Are you familiar with any of the previous lawsuits that have happened in LA for competitive or non-enforcement reasons?
Yes, with some of them, and some of those lawsuits do raise the same type of statutory remedies that I'm discussing here. So not to get too into the weeds here, but there's a couple important statutes that California has on the books that consumers or businesses can use to protect themselves, but also statutes that people can abuse. And in particular with the cannabis industry, and with so many regulations of such granularity that even companies that are with best intentions trying to be compliant sometimes can't be fully compliant, even with with good faith efforts. And my fear is that these statutes will be used more offensively by attorneys and consumers than as a shield by cannabis companies that are protecting themselves from unlicensed or underlicensed entities. But the two statutes are the unfair competition law, and this is California Business and Professions Code 17200, and the Consumer Legal Remedies Act, and that's California Civil Code 1750. And both of them, again, I don't want to get too detailed here, but they allow consumers or companies that have been injured by deceptive trade practices or unfair competition, things like false advertising or misbranding or things of that nature, to bring suit and to have these benefits of those statutes. And the benefits are things like being able to demand accountings of the business and to disgorge profits if those profits were wrongfully gained. The attorney's fees. So if you bring a suit under one of these statutes and you win, you get your fees back, which is a huge deal because in most civil suits that doesn't happen, and it acts as a barrier in many cases to people bringing suit because they can't afford a lawyer or they don't want to sink that investment in on the off chance that they may win a large judgment. And then in some cases, again, they allow punitive damages, which can be very dangerous, and causes of action or complaints that contain these causes of action frequently are uninsured. And so if you're a company and you're facing one of these lawsuits, sometimes it's hard to get adequate insurance to cover all of the alleged damages. So again, this is what happened to the dietary supplement industry over the last 20 years. And keep in mind that that's an industry that is only quasi-regulated. There aren't many statutes that really specifically apply to those businesses. And even they had a hard time dealing with this type of lawsuit. With cannabis, with the number of state and local regulations that these companies have to follow, it's a much easier lift for an aggressive attorney to locate violations and bring these suits under those violations, even if they're not terribly to an outside observer, even if the violations don't appear to be terribly onerous. I just think that this is one of those areas where we're going to start seeing an uptick in this kind of suit as the industry matures, brands become better known, insurance, such as it is, becomes more widely available, and the plaintiff's bar believes that these are deep pockets. Once that happens, and we're looking, I think, still at a number of months away, but I would not be surprised at all if we have this conversation again, Kristen, in early 2019, and we don't see dozens or hundreds of these lawsuits out here in California.
It's a perfect storm. I can't imagine that this isn't just going to be a thing. It's tempting to want to go. I mean, personally, I am here to call bullshit on all of these scammers and people that are misrepresenting and doing other people wrong. There's so much bullshit in California specifically that I think I would make an excellent class representative. I'm like, dude, you know what? I don't want to work ever again. I just want to call bullshit. So maybe I should be a professional class action person who, like, because I know where the bullshit is. It's a very easy thing for me to find. And I can't believe that there aren't already law firms out there that do this. This is such an easy industry to take advantage of with these lawsuits because the regulations are so difficult and they're so fractured. And it's nearly impossible to be completely, 100% within the licensing or the regulations in a new market like California, where they're going to be changing a lot. I'm so surprised that there aren't already predatory lawyers and other people, especially while insurance companies are still warming up to insuring cannabis companies.
Yeah.
Then this is like the perfect time to go in there and get them.
Yeah, no, I think that's right. And what we've seen have been over the years waves of this type of predatory lawsuit, starting, for example, back with the lemon laws and breach of warranty type litigation. We've seen predatory lawsuits based on ADA violations. We've seen predatory lawsuits based on Prop 65 violations, and there are firms that specialize just in sending out Prop 65 notices or ADA violation notices. And I think that there are going to be a handful of firms that are going to specialize in sending out this type of notice with regard to cannabis companies, for sure.
This reminds me that California is known for being incredibly litigious. And I believe I read sometime in the past that medical liability lawsuits in California have a cap at $250,000. Like, it doesn't matter if they cut off the wrong leg or they killed your family member. There's no more than $250,000 to be made because it wouldn't be possible for doctors to continue to work with the insurance policy premiums that they have because everyone keeps getting sued. Am I remembering that correctly? Have you heard of something like that where they actually cap the winnings that you can get?
Yeah, yes. What you're talking about is what's called the micro cap in California, and under micro, depending on the type of damages, there are caps for the non-economic damages, the pain and suffering type damages. The caps are less relevant to the economic damages in terms of actual out-of-pocket medical expenses and that kind of thing. But yes, absolutely. And that tort reform has dramatically decreased the number of medical malpractice lawsuits in California.
Interesting. Okay, so let's go back to Brass Knuckles and C.L.A.B. I'm more curious about C.L.A.B in this case because I know that they have worked with everybody. I mean, they had a contract with Weed Maps where they were doing the testing for everyone that was posting on Weed Maps. I mean, that's huge. So in this case, it appears that they gave false negative results for Brass Knuckles. So it said that there was no pesticides and that the potency was a certain amount, except there is pesticides and the potency wasn't the right amount. How liable is Brass Knuckles for that, and how liable is C.L.A.B for that?
Well, those are good questions, and keep in mind that all the information that I have at this point, or that the public has, is just what's alleged in the complaint. And frequently, being a defense attorney, so all I do is defend lawsuits. I don't typically bring lawsuits, though occasionally we will if it's a competitor suit. But as a defense attorney, what I frequently see are that at the end of the day, when all the evidence is in, some of the allegations in the complaint may be accurate and some may not. And but if we take the complaint at face value, it's alleged that there are basically two primary allegations in the complaint. One is that there were statements on the label and marketing of the Brass Knuckles brand for vape cartridges that said that they were lab tested and contaminant free. And the allegation is that they two flavors of the vape pens were tested at Steep Hill, and that a number of pesticide residue levels above the action level set by the state of California were present. Now, does that mean that there was any kind of intent there? No, that's a whole other issue. I mean, maybe there was, maybe there wasn't. I can't comment on that. But that's the allegation, and if they can prove it, then de facto there's a violation of the regulations, and there's potential exposure under these consumer statutes that I mentioned, as well as traditional tort theories like breach of warranty. The other allegation is more of a false advertising with regard to a statement on the label of the vape cartridges that says the most potent THC cartridge available. And again, what the plaintiffs are establishing their theory of liability by comparing the potencies seen through tests done at Steep Hill of the Brass Knuckles brand versus other similar brands. And the allegation is that when they tested other similar brands, they actually saw higher levels of potency. So again, it's one of these things that's going to be all about the evidence. And once Brass Knuckles has lawyers that get into it and have their own testing done to challenge the evidence, well, it'll shake out through depositions and through document production and potentially through a trial, and we'll see where it goes.
I think this is the most interesting part of all because I worked at an analytical testing lab, and having managed an edible company and doing all of the formulation, I relied very heavily on analytical testing labs to give me the correct amount of THC for me to be able to formulate the edibles. And the biggest problem in all of the legal states is that the labs are essentially the regulators of the industry, because if you don't pass their test, you don't go to market. However, nobody is regulating the labs, and no one is saying this is how you do your testing. Everyone has standardized testing protocols. That doesn't exist yet. So I have used I remember I would send a test or a sample to 3 different labs and then compare all of their results. And then I would send the same sample to the same 3 labs and then compare the results within each lab. And they were always different. And I think that's going to be a huge problem when it comes to proving. I mean, who's to say that Steep Hill is testing correctly and that SC Labs wasn't, or vice versa? And
Yes.
what if they have completely different testing protocols? So then how do you even prove? Then do you have to use another lab to make sure that Steep Hill's results were correct? And then if you find that lab and they're like, no, we didn't get that, then it's like,
Right.
who is liable? Like, who are we suing,
Absolutely. And so this is what you just described is a problem that's happened in other industries. And so, for example, food contamination cases that my firm has dealt with over the years has seen this kind of problem with regard to what tests are required in what circumstance and how is the validation done for those tests. And what the validation means is, okay, you can have a procedure by which the test is performed, but is the lab performing that test properly, and are they recording it properly? And that's the validation part, and that's actually the most important part in terms of determining whether the results are really probative of what is in the product. Here with cannabis, there has to be standardization, and so for testing labs to operate in California, they have to be ISO certified. And ISO is the International Standards Organization, which basically mandates that labs have certain equipment and are able to do certain tests. But what's lacking is a uniform agreement, not only between states, but between types of products and even labs within states as to how they do these various tests. What we need really is a uniform national standard, and in the absence of real legislation, that's done through third-party standard organizations like ASTM. ASTM is the American Society of Testing and Materials, and they are coming up with a third-party cannabis standard, which will include testing labs. Now, will that be adopted by all states? No, not necessarily. However, what it will do is it'll create an outside third-party standard, and it could be a de facto standard of care, because what will happen is plaintiff lawyers, for example, will use that standard and they'll challenge labs during depositions in a trial to say, why didn't you meet this standard? And juries could potentially find labs at fault for not complying with that third-party standard. So we'll see where it all goes, but we definitely need to have an agreement on what the minimum standard of care should be for these labs.
I think also we need to have When it comes to pesticide testing, some labs don't even test for all of the chemicals that other labs do. And some labs, their equipment is only so sensitive than the other labs. And it's just such a mess. And I'm shocked that this hasn't been addressed in Colorado or Washington or Oregon, where these issues have happened already in the past, was it 4 or 5? No, 6 years, I think, since Colorado came online, and it still hasn't happened. I think this is going to be like a major, major problem in California because the labs are all very divided still.
Sure.
And the labs are the defining people. So that's, it's going to be very hairy coming up. But that's the other question I had is, could brass knuckles just be like, hey, that's what they said. That's what the lab said. How are we supposed to know?
Well, it's not quite that simple. I mean, yes, one potential defense for brass knuckles would be that they relied on the lab tests, but keep in mind that under certain types of theory. So, for example, if this was a product liability suit where somebody vaped the product and was injured because of pesticide residue, the very fact that brass knuckles is in the chain of custody means that they're potentially liable for that product if it's contaminated. For a consumer suit, the issue then becomes were they in violation of the regulations. Again, they're a licensed manufacturer, and ultimately they have a non-delegable duty to sell product that is clean under the regulations. The question then becomes: is there some other risk transfer option between the parties, like an indemnity agreement, insurance, things like that that brass knuckles could use to transfer some of that risk onto a more culpable party like a lab potentially. But we'll just have to see how that all shakes out.
So do you think that if this court case proves or they find that SC.Labs is liable, then could that open up a bunch of lawsuits against SC.Labs by their current customers?
Well, so if a class is certified based on these sales, the sales of the brass knuckle vape pens, then all customers who purchased those products within the class would be certified and be part of the class. And in that case, I don't want to get into too much detail, but there are procedures for opting out of the class where people, if they think that they have their own suit and they want to bring that suit, they can go to the court and petition the court during the class certification process and say, you know what, I don't want to be part of the class. I want to go after, whichever defendant myself. And then depending on what the court hears, the court may allow that opt-out, which would then allow, individual claims. My experience has been that, opt-outs typically are pretty low for this kind of case. And if there are no opt-outs, then once the class is certified, nobody else can sue. It would just be within the class.
But but if another company that uses SC.Labs sees that SC.Labs was being held culpable for not having the correct test results, and then they're like, I wonder if my test results are okay. They go to another lab, then they're not part of the original class, right? They could be their own class. That's different.
Well, they would have their own cause of action potentially, and what can happen is that another company can potentially use the evidence that's generated in the brass knuckles lawsuit to bolster their own claim against a lab or SC.Lab, potentially. Again, and I mean, this is just what's alleged in the complaint. I don't want to assume that SC.Lab is guilty of anything at this point because it's just alleged in the complaint. So just to be fair, but so we're just speaking hypothetically here. But yes, another company could potentially do its own testing and use evidence that's generated in the brass knuckles lawsuit to assist it in proving additional liability. Again, that's just hypothetical.
I know. I'm sorry. I keep going off on SC.Labs, but they're the ones in this case, and I'm just thinking if SC.Labs was like, we retested, it's Steep Hill. Like, Steep Hill is the one. Could SC.Labs sue Steep Hill and say you misrepresented or you came up with a false positive?
Well, I mean, I suppose there's a potential fact scenario there, but it would all be based on the facts. If hypothetically again, if Steep Hill was shown to have really messed up its testing and the results were incorrect, and this led to the lawsuit and harmed C.L.A.B's business, then yes, I mean it could be an actionable claim against Steep Hill. But again, that's all just hypothetical.
Yeah. Wow. It's a hairy situation. I definitely seeing this going downhill really quickly this year, because while everyone is still trying to get into compliance, California is overwhelmed with dirty product. And I don't know where the dirty product is supposed to disappear into, but I have a feeling that it's still getting into the supply chain. So people are not out of the woods yet, which makes me actually wonder, is the state liable for not staying on top of getting these? Like, they just extended the the grace period another 6 months for licensees. I'm like, wow, you could just sue everyone here. Like, everyone's culpable for something, does that ever happen where one lawsuit just sparks another one against another one, and then everyone is just suing each other?
Certain types of lawsuits, absolutely. There are, think about the rash of lawsuits involving head injuries and alleged cognitive deficits from brain injury. Okay, so what happened there was a few years ago, there were some high-profile lawsuits with huge verdicts, huge jury verdicts, coming out of new research and new means by which plaintiffs' lawyers are proving alleged brain injury from even relatively minor injuries where the person doesn't lose consciousness, or otherwise you wouldn't think of it as being a terrible head injury case. And that gave rise to a rash throughout the country of lawsuits that are alleging these very, very dangerous brain injury allegations. That's just one example, but there but the answer to the question is yes. It's all about what works, and there are new strategies being developed all the time in the legal community for holding companies accountable if they're being bad actors, or like I mentioned before with the Prop 65 and ADA compliance and these things. Sometimes you could say that those statutes are abused, that they're being used in a way that they weren't intended to be used in terms of creating civil liability.
Interesting. Okay, one last lawsuit question. What about, and this is different from class action, but I'm just curious. I think I read somewhere only 1/3 of the state is actually regulating its cannabis industry locally. So there are 2/3 of the state that still have cannabis businesses operating, but they don't have any way to be legal. Is there any recourse for these companies that are in these dry zones in the state to sue the state to be like, this isn't even possible, like this isn't plausible, or you messed up by giving them too much freedom and now you're messing everything up? Or is there no recourse because it's a state regulation to give the cities the right to opt out?
I've never considered that question carefully. However, my gut tells me that, well, let me put it this way. I can't think of a recourse. I would be surprised if there was one, frankly. I mean, the state regulations have allowed local control. So obviously, Kristen, you know that we have to have a state license and a local permit. And those localities are allowed to choose whether or not to license commercial cannabis activity. If a company is currently operating in one of those dead zones, at this point, the only realistic option is to move, unfortunately.
What about Calaveras, where all these people paid for everything, they got their licenses, and then someone changed their mind on the city council, and they're like, oh, banned, like, sorry, everyone shut down. Yeah. Can those companies sue the local government for leading them on, taking their money, and then shutting them down?
That's a highly factually specific inquiry, but generally speaking, I will say that absent certain immunities that governmental entities have in California, there potentially are causes of action against governmental entities for what's called detrimental reliance. So that's if the government acts in a certain way and it causes reliance through blood, sweat, tears, money of the person, and then the defendant entity unreasonably does something to harm the person by causing him or her to detrimentally rely on the action, then yes, I mean that would be the theory most likely. But again, I haven't looked at that carefully, but I would think it's possible based on the facts.
Yeah. Okay. I mean, that's a class to me, all those people up there. That's more than a couple dozen, people that were affected by it. But I digress. My next question is, how does a company protect itself from such lawsuits if they trust the lab is giving them the correct information?
Well, and this is what my team has been out to talk about to the industry, not only the cannabis industry, but also the insurance industry and other risk management trade groups, to generate this discussion about compliance. And when we've heard, think about last year. Last year, the industry, especially here in Southern California, I think, was, the mantra was licensing, 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 right? And then late in the year, early this year, the mantra has now changed to compliance, compliance, compliance. And that's great, but the focus has been wrong, or at least incomplete. The focus on compliance has been protect the license and minimize or mitigate the risk of penalties by the government. Okay. And that's important. However, the real company killers for lack of compliance are these lawsuits, the competitor lawsuits and the class action lawsuits. These are the ones that kill the companies. And people aren't really focusing on that. Can you fully protect yourself from these suits? No. All you can do is create good due diligence programs. Do your best to institute best practices for compliance. Work with people that have a good reputation. Know your business partners. Work with good labs. Can you fully protect yourself if a lab doesn't fulfill its obligations? No, you're going. Hopefully you will have some contractual protections if you have a contract with the lab and it turns out that you're harmed because of the lab's negligence or error or omission, then you should be able to get indemnity from the lab. But other than that, that's really all you can do.
So I see California going from nothing on paper, no bank accounts, nothing, to like the most insane paperwork where it's like, this is all you, like that's your fault if you do this, like I'm not held liable for anything about anything, like 40 pages of documents to protect themselves. I mean, you're a lawyer, you do defense, you're sticking up for these companies. Do you see that happening where people are really beefing up their contracts?
Yes, not across the board, but yes. I mean, certainly companies are realizing that risk management has to be a core mission for the company, particularly in the cannabis space, and so they're actively preparing SOPs and employee handbooks and checklists, and understanding what the obligations are under Cal/OSHA and other things of that nature. And so that's just the way it has to be. And unfortunately, it sucks if you're a business that has been in the space for years, and I know that there's a lot of people out there that aren't used to this, but unfortunately, with the amount of market opportunity and profit that is potentially out there, in order to ensure the public that cannabis is going to emerge in a mature and safe way from the gray market, this is just one of those necessities in order to play in the sandbox.
You got to paper up, right? Cover your ass in every possible way, which, obviously, this is a federally illegal drug. So you would be very stupid to take risks in any way getting into this industry. It costs enough to play the game, but to be able to lose it over, almost anything, it doesn't make sense to not lawyer up and paper up as much as possible. One last question I just thought about ease. I find that less interesting because the terms of service for any technology that we use, nobody reads it, and they're incredibly in-depth. And it appears that, according to, I forgot who it was at your law firm who had wrote the paper about the ease thing, is that it's covered in their terms of service that if you agree to use the website, then you're you might be giving away the right to have them blow you up with text messages. So it's a lot different than packaging with the wording on it, right? When it comes to technology, I find that's going to be a lot harder because they can give you all kinds of terms of service you're never going to read.
Right, and there's been a lot of lawsuits and court decisions in a number of jurisdictions over the last 5, 6, 7 years as web and app-based platforms have become more common, and these terms of use issues have caused frustration, like with SMS or text blasts, things like that, and it's all about how the terms of service are communicated, how effectively the information is communicated, how the customer gives his or her consent, how clear that is. These are the kinds of things the courts look at. But that ease case was brought under a federal statute called the TCPA, which is the Telephone Consumer Protection Act, and it's designed to prevent invasions of privacy into people's private lives by robocalls and unwanted texts and things like that. But the TCPA is one of these statutes that was written before technology sort of outpaced it, and so it has to be consistently updated, and there has to be new judicial opinions. So this is just one of those areas that's developing, and ease was caught up, I think, in a situation that other non-cannabis companies have been facing for a number of years. But it is, if you're a technology platform and you're communicating with customers, it really is important to understand what those obligations are, because again, this is one of those areas of law where if you unwittingly trip up, the consequences can be very severe in terms of the potential damages, and the cost of this litigation is just really, really high.
The TCPA is failing, man, because I get so many robocalls. It's unreal. So I feel bad for anyone that gets caught up in it because,
There was an article, I think it was in The Economist recently, but there's been an uptick in reporting on how robocalls are back, and the way that people are using internet, VoIP and means by which they can screen identity. These companies are, ignoring the robocall laws, and I agree with you. I'm getting way more than I used to.
I actually read somewhere where it's like, don't even answer your phone, because all they want you to do is answer it, and they put you on an active list, and then you get blown up. Or one of them was like, all they want you to do is say hello, and then they record it, or something like that. It's like, at least I don't feel guilty for never answering my phone anymore. Now that's just kind of common practice. But I thank you so much for coming on, and I see a very great future for lawyers, writing contracts and sticking up for their clients, because I definitely see in California a lot of lawsuits coming, and I'm really interested to see what you guys have to say about it in your legal briefings, because you guys write about it so well, and I think we're going to be changing a lot of laws in California. I mean, as far as protections for the companies or for the people, when it comes to cannabis, California has always kind of been the place that sends ripples out to the rest of the country. So I'm curious to see, how bad it gets,
Yeah, absolutely. I mean, look, California is it's a great opportunity. It's a great market, but it's also, a difficult place to do business sometimes. We're just really pleased to be, in this space and trying to, do some exciting new things and helping companies with some of these new issues. And thank you, Kristen, for having me on. Appreciate it.
Yes, absolutely.
The Cannabis Detector is produced by Soil to the Oil Media.